talk about a disability policyholder who was talking out of both sides of his mouth. What do I mean? I'm going to tell you about a case where the disability policyholder was claiming that they were disabled and entitled to benefits because they were unable to work, and on the other hand, had filed an employment discrimination claim against the employer. Filing inconsistent claims can backfire on a disability policy or plan beneficiary. And I'm going to tell you the story of Mr. Frost. Mr. Frost was a volunteer firefighter and emergency responder. He was injured in 2007 when a burning building collapsed on him. He sustained horrific injuries. He had fourth-degree burns over 60% of his body. He had an amputation of his left arm and his right leg. Fortunately, he was insured by Provident. And under the terms of the policy, he was eligible for up to 5 years of own occupation benefits if he was unable to perform his own occupation, and thereafter was only entitled to benefits if he couldn't perform any occupation. In 2017, his doctors stunningly said he no longer had any restrictions and limitations. I mean, to me, that's just outrageous. But Provident jumped on it and they terminated his benefits. Nonetheless, he said, I'm going to try to go back to work. And he thought he could work as a paramedic with accommodations. He first attempted to obtain employment with the city of Philadelphia. And then he claimed that he was terminated when the extent of his disabilities became known. He filed a federal lawsuit claiming discrimination, and the court found that he could perform the work of a paramedic and that his termination was because he failed a retest at the fire academy. So he proved to the court's satisfaction in the discrimination claim that he could work as a paramedic. But Frost wasn't done. He turned around and sued Provident, claiming he was entitled to any occupation benefits because he couldn't do any occupation. So which was it? Could he be a paramedic with accommodations, or couldn't he do any occupation? Well, I will tell you the federal judge in Frost versus Provident was not happy and said, look, you can't have it both ways. You successfully argued in your discrimination case that you could work as a paramedic, and now you're claiming that you're disabled from performing any occupation. The court said, look, you're collaterally estopped from bringing this disability lawsuit. In other words, you picked your poison, you picked your remedy, and you can't have both. Perhaps filing the lawsuit against Provident was an afterthought when he filed the fire academy test. But you have to think through your causes of action, and the fact that one may conflict with the other can be a significant problem, as you can see in the Frost case. So don't bring in inconsistent claims, and don't make inconsistent allegations in all sorts of claims, an employment termination case, an employment discrimination case, your disability case. Just don't do it. Got it?